to Lunch with a Lawyer. This is a broadcast, and we are looking for you to call in with any questions that you'd like to have answered by a lawyer, and you can post those to our Facebook page, and I will either answer the question, or if I can't answer it, well, I'll tell you that I'll get back to you or try and refer you to someone else, and that I don't know all areas of the law, but whatever you have, or if you do have any questions, well, please post them on Facebook, and we will see about answering them during this broadcast as far as that's concerned. The topic we're going to start out on today is who needs a will? Well, the easy answer to that is if I believe everybody, it's not a matter of if you're going to die, it's just a matter of when. And so that's what the will does for everybody, to say, well, what you get to designate who you want to receive whatever assets are titled in your name. So a will is usually done in conjunction with estate planning. And many of the folks that come to want a will drawn up really are in need of estate planning, because there's usually two questions that everybody wants to know about what happens when they pass on. One is the government going to take any of my money, or my heirs, are they going to have to pay tax on it? Well, the federal government has raised the estate tax limit to up over $5 million. So if you have less than $5 million, like most of my clients do, then there is no estate tax to the federal government. The state of Florida has gone one better, and they have eliminated the estate tax so that there's no estate tax or payable to the state of Florida. If you would pass away and own property in another state, that state may impose an estate tax on the value of whatever property is in their state, even though you died in the state of Florida. So that's one of the questions a lot of my clients want to know when they come in to have a will drafted, or more importantly, estate planning documents. The other one is most folks are concerned about the cost of probate, or the cost of administration of their estate after they pass away. So with some estate planning, we can discuss with you your various options, such as retitling your assets. There is a way that you can take your real property and maintain control over it over your lifetime, and be able to sell it, do whatever you want to with it, but upon your passing, it automatically vests in whomever you would like it to vest in, such as a child or two children or something like that. That's called an enhanced life estate deed. Many people you may have heard, it's been labeled in a treatise called a Lady Bird deed, and so that's named after Lady Bird Johnson. So that's one way to avoid probate of your home, and that's a much better alternative than adding someone to the title to your property, particularly if it's your homestead. You don't want to add anybody, because then they're a part owner of your property rather than just receiving it upon your death. So with the will, we basically set forth what I call your testamentary scheme, or who you want to receive your assets whenever you pass away. And there may not be any assets that you want to that will be in your name, particularly if you do the planning, set up your bank account so that they're payable on death to whomever, particularly if you have 2 or 3 children and you want them to share equally, then it's easy enough to set up your bank accounts. Also, annuities have beneficiaries, so they're not subject to probate. You just need to verify your annuity, who the beneficiary is. Same thing with your IRAs, and with life insurance, they all have designation of beneficiary forms. It's important for you to have a copy of your beneficiary designations for IRAs, annuities, and life insurance policies and keep them in your files or with the policies. So when you pass away, whoever that sees your paperwork will know what beneficiary to contact so that they can file for the death benefits. So getting back to the will does cover who you want to receive it, and so if there is any assets that you haven't retitled or provide for a survivorship provision or a designation of payable on death, then the will would control that. You can designate whomever you would like. You also get to designate who you want to be in charge. And many times the old Latin terms for the person who you put in charge of your estate is called an executor, and that's for a male, executrix is for the female gender, and administrator was for a bank. Now they change it to personal representative. It looks like Josh has given the high sign that we have a question.
Is my will valid if I move to another state, or should I redo it with an attorney in the new state?
The answer to your question is I can't tell you about any other state. If you move out of Florida and you go to another state, I would more than likely it is valid in another state as far as that's concerned. I would urge you, however, to contact an attorney in whatever state you happen to live in or move to and ask him about the laws of that particular state, and also review your estate plan as far as that's concerned, because in Florida we recognize wills that are executed in just about every state. One thing that Florida does not recognize is what they call a handwritten or a holographic will if it doesn't have two witnesses. Florida also has in its laws will not allow a person to serve as an executor, or now we call them personal representative, and done away with the Latin term, if they're not a blood relative or a resident of the state of Florida, which is somewhat peculiar or different about Florida laws. I don't know what the laws of any other state are, so I can't tell you with certainty that your will would be valid, but that's more than likely it would be. Whenever you do your estate planning and also do your wills, it's really important to also address 3 other documents whenever you do your estate planning. The first one is to have a living will or a dying declaration. Then the statutes provide 3 circumstances wherein you can designate to have life support discontinued. It's if you have an end-stage condition, if you have a terminal condition, or a permanent vegetative state. Most of my clients are very much concerned about the permanent vegetative state, and we had the case several years ago of Mrs. Shibo, who didn't have a written will. Before we move on to the next document, looks like Josh has another question for us.
How can I dispute a will of a family member if I feel they made it in an unstable state of mind?
That is a very challenging question, and what you really need to do is contact an attorney as far as that's concerned in order to have to show that the person was not competent or was was unduly influenced by someone. You first need to have probably physician statements, because whoever witnessed the will, that's who you're going to be attacking, and particularly if it was done by a lawyer, well, then you're going to have problems showing that the lawyer didn't ask them the questions or didn't felt like they were competent, or he wouldn't have had them sign the will. The threshold for making a will is only that the person is aware of who their family members are, who the natural bounty of their estate would be, such as their children, as far as that's concerned, and also the extent of their estate, to have some idea of what their assets are. You can have folks that are not always competent, but that's not the test. It's a question of whether or not they're competent and can know who their heirs are and what how much they have at the time they executed the will. So if you undertake a will contest, it's really very helpful to have a physician, or that they've been to see a doctor, and you can show that they're suffering from dementia, or even if they've been declared incompetent, then that would be certainly a basis to be able to challenge the will as them not having the requisite mental capacity. It's the other time that you can challenge a will is if you believe that someone has influenced them. Well, then there are certain components or questions that you ask that can raise a presumption as to that person. If they've been designated as a disproportionate beneficiary in the will versus the other children or whomever, you can ask the question as to, well, did the person have the power of attorney of the person making the will? Because that puts them in a position of trust. Another one is who set the appointment up with a lawyer? Was it the person who's designated? Did the person who is in the will, did they attend the will conference and take the person to see the lawyer to do that? Were they aware of what was being put into the will, or did they sit in on the conference? Another is, did they bring the person to the lawyer's office to have the will executed? Did they serve as a witness as far as the will is concerned? So all of these questions, if they're present, then you're in a position to challenge the will, and that the person was unduly influenced because, and it's up to the person who is written into the will to then overcome the presumption of undue influence if you can show some of these factors as far as challenging the will. I would say that there needs to be a substantial amount of money involved before you undertake doing a will contest, because usually they're handled on a contingency fee basis, because the attorney fees to do a will contest are very substantial. Josh has another question for me.
The question is, when should I redo my will?
That is a terrific question, in that you should redo your will anytime there is a change in circumstances, such as if you have an additional child, if your children reach the age of majority, and or they're minors and you want to change who the guardians are, or if you have some problems as far as one child or a beneficiary dying, whether you want to provide for grandchildren, whether you have a problem with a particular child, or the child has any kind of an addiction problem or other problems that you are concerned about them receiving the money, or that they have fallen out of favor or decided not to have anything to do with you, well, you may wish to then change your will. So it's basically a matter of changing your will. Another good one is in the event that you would become divorced, well, you need to redo your will at that time, although if you get divorced, the law is that it's presumed that your ex-spouse predeceased you, but you still need to decide whom you would like to make health care decisions for you and who you wish to leave your estate to. So hopefully I've given you the examples and answered the question as far as that's concerned. Also, if you want to change who you want to leave in charge of it, particularly if you named a friend and then your children are now old enough to change who you want to be the executor or personal representative. Josh, you got another question?
This one's a little off topic. The question is, what advice would you give to someone considering a career in law?
My advice is to you is that you follow your passion, and that if you wish to explore practicing law, well, that's great. It's a long haul. To get there, you have a 4-year degree, which is 4 years of college, and then you have 3 years of going to law school, and then once you go through law school, you have to pass the bar exam. Right now, the cost of going through law school, particularly if you have to borrow the money or with student loans, you're probably coming out of law school with $100,000 or $150,000 in debt. Fortunately for me, I didn't have that problem, 45 years ago when I became a lawyer. It wasn't quite that expensive, but you probably will find yourself in debt. Right now they have over 105,000 lawyers admitted to the Florida bar. So the problem we have is numerous young lawyers just coming out of law school are not employed. So as far as thinking that you're going to make a lot of money being a lawyer, well, that may not happen. And the bigger problem is actually finding a job, or even if you're willing to work for nothing to try and get experience. And that as a lawyer that's been practicing a long time, what I do is I know what I'm doing because I've had the experience and get it done. So whereas when you come out of law school, the practical application of getting it to what you know or you think you know, and then the real life experience and interacting with the public, that is a problem. If you graduate at the top of your class, you then are probably in a position to then maybe get an offer with a larger law firm sometimes, and then trying to figure out what area you'd like to practice in. And so that's another problem as far as that's concerned. It is very difficult as far as once you graduate, and if you can't find a job, is to go ahead and open up your own practice. You first off got to be a good business person to be able to operate a business as well as practice law, and that's very difficult and to do both. And in fact, you can get yourself in trouble in a hurry, particularly dealing with your trust account. So it is challenging to, even if you want to be a lawyer, well, that's great. You may be able to get a job with a public defender or with a prosecuting office right out of law school. Even those jobs are getting difficult. Maybe get a job with volunteer at legal aid to get some exposure, and before you're able to actually get in with a law firm or a lawyer to start practicing law as far as that's concerned. So I don't want to, if you got the passion, well, you need to follow your passion, because if you're doing it for the money or it's a job, well, it's too high stress and difficult to make it work. So I urge you to, if you want to be a lawyer, well, go for it. You might want to, hopefully they have some, I don't know at what point you'd be able to mentor with a lawyer, but those are hard to find also. Josh has another question.
Yeah. From email, if a homeowners association prohibits motorcycles, is this legal?
All right, I think that they can put that in their restrictive covenants as far as prohibiting motorcycles. They can prohibit, trucks. So whenever they do that, so I believe that probably if they put that in their restrictive covenants, they would be able to try and enforce that as far as your as far as a motorcycle is concerned. I don't know that they can prohibit your riding one, and then if you keep it inside your garage on what they're going to do as far as the restrictions concerned. Usually, as far as trucks are concerned, the restrictive covenants say that you can't park the truck out, on your property. Whereas if you put it in a garage, well, then it's not a problem. So the restrictive covenant cannot, I don't believe that they can keep you from riding a motorcycle in your subdivision, and whether or not they can prohibit you from maintaining a motorcycle inside your garage, that would, as long as you don't keep it outside. So there may be some challenges as far as that's concerned, but the last thing you want to do is to wind up litigating with your homeowners association, because it's very, very expensive, and then you could wind up paying attorney fees and whatever. So at this point, I've given up on trying to work, trying to litigate or challenge homeowners associations, just because of the expense involved for my client. So it'd be interesting how they craft a restrictive covenant about having a motorcycle. We have another question. Y'all doing great on asking questions here. This is a great session.
The question, I believe, is can you live in a van in Pasco County?
All right. Can you live in a van in Pasco County? I don't know, but I don't have an answer to that. I think you may have a parking problem or whatever on where you keep the van or whatever, and certainly if you have any, it may be. There's lots of people who camp out in the woods or whatever else, as far as that's concerned, and so I guess if you live in the van, well, it depends on where you park it, as far as that's concerned. So you not supposed to trespass, and so that's a problem. Not supposed to park on the streets. So, but I don't have an answer for that. I'm just trying to give you an answer using a little dead reckoning here.
Another question. Does an LLC corporation provide corporate protection when a single 100% shareholder exists with no other partners or shareholders?
All right, first off, you're running two things together. An LLC is a separate statute, and it's a limited liability company, and it's sort of a hybrid between a corporation and a partnership, which provides for limited liability. So you don't have shareholders in a limited liability company, you have members. So in answer to your question, once we get that, I didn't mean to go off on a tangent here as far as understanding the difference between an LLC and a corporation. And if you have a single member LLC, then it may not afford you liability protection if you're the sole member of an LLC. So if you do set up an LLC, you may want to name have a 1% partner as far as that's concerned, so that, and file a partnership return, and I urge you to have an operating agreement. Whereas with a corporation, you can have a single shareholder, and that's a stockholder, and not have any exposure versus a LLC. Got another question, Josh?
Yep. Do I need more than just a will?
Do you need more than just a will? Is yes, you do. You need a living will, which I started talking about, and then we got some questions, so I'll get back on track. Then you also need what they call a healthcare surrogate. That would be in the event that you would go in the hospital. This authorizes the medical folks to release your medical information to whomever you designate, and further, it authorizes the person you designate make medical decisions for you in the event you're unable to do so. So that is in addition to the living will, which you also designate a healthcare surrogate to determine you direct and authorize discontinuance of life support in the event that you meet the medical community determines that you have a terminal condition, end-stage condition, or permanent vegetative state. The fourth document signed, the will, the living will, and the healthcare surrogate, is a durable power of attorney. A durable power of attorney is where you appoint an agent to act in your behalf, although you can continue to act. And this is called durable because it survives your incapacity, and we use it quite often as far as estate planning is concerned, to avoid having to use a guardianship. And so it works very well whenever if a person becomes incapacitated. It is also somewhat convenient in the event if your spouse or whomever is going to be out of town, out of the country, or whatever, and you need someone to execute documents for you, then the agent who you appoint is authorized to handle that. They changed the power of attorney statute several years ago, and also to set up do some Medicaid planning for the decedent, and so you can also use that to talk about conforming your IRAs and other estate planning documents to your estate plan. So I'm giving the high sign here, and I look forward to seeing you next month on the second Tuesday about 11:30 with a lunch with a 727.
I can't take us off the air. I muted the microphone though.